Hi, good afternoon, everybody. Thank you for joining our webinar. This is Shuming Cheer with the National Immigration Law Center, and we host these webinars regularly to provide you updates and information on hot topics within immigration. And we all know we've been thinking a lot about DACA, given what's been happening with the program. So today we have several speakers with us who are going to talk about what to expect with the upcoming Supreme Court hearings. So joining me today, we have Josh Stehlik, who's the Deputy Legal Director here at NILC. We also have Rosa Barrientos, who is the California Dream Network Northern Region Organizer with the Coalition for Humane Immigrant Rights, CHIRLA. And we also have Alisa Daubenspeck, who is the Managing Attorney at the Central American Resource Center, CARECEN. So they're going to go over what to expect with the Supreme Court hearing, also some of the actions that are happening on the date of the Supreme Court hearing and what you can do to support DACA recipients. And then Alisa is going to talk about DACA renewals and provide you some tips and information about that process. We'll make sure to leave some time at the end for your questions. So as you have questions, please put them into the chat box, and we'll be looking at them during the presentations and then asking our panelists those questions afterwards. So now I will now turn this over to Josh.
Thanks, Shuming, and thanks everybody for joining us today. As Shuming mentioned, my name is Josh Stehlik. I'm the Deputy Legal Director here at the National Immigration Law Center. And for those of you who are not familiar with NILC, we are a nonprofit national legal advocacy organization that works to advance and defend the rights of low-income immigrants. So I'm going to talk a little bit about the current set of cases involving DACA that are pending before the U.S. Supreme Court. Next slide. So just to take a step back, and provide some big picture context. As I'm sure most folks on the call know, the Trump administration announced the termination of the DACA program on September 5th, 2017. And in the wake of that announcement, several cases, including one of NILC's, were filed to challenge the process by which the Trump administration ended the DACA program. And then several district courts, including in California, in New York, and the District of Columbia, determined that the DACA termination was not lawful and issued injunctions that permitted individuals who had or who have DACA to continue renewing their DACA under the court injunctions. The government then took the rare step of seeking what's called certiorari before judgment, meaning it sort of asked the Supreme Court to take up the sets of cases challenging the termination of the DACA program before those cases had fully made their way through the lower and appellate courts. And ultimately, in June of this year, the Supreme Court granted the government's request on all three sets of cases, consolidated the cases, which means it's going to hear all three sets of cases together in a 1-hour oral argument that is scheduled for November 12th at 10 a.m. Next slide, please. And as I mentioned, NILC is counsel in one of the cases, Bataya Vidal v. Nielsen, that is pending before the Supreme Court. So the court will hear oral argument on all three sets of cases on November 12th, and will then issue a decision sometime between November 12th and the end of the court term on June 30th of 2020. In the meantime, the lower court's injunctions do remain in place, so anyone who has or who has previously had DACA can continue to apply for renewal, and we encourage individuals who are eligible to apply for renewal to do so. Next slide. So now I'm going to turn and talk a little bit about possible outcomes at the Supreme Court. So one outcome could be that the court decides that the Trump administration's termination of DACA is not reviewable by the courts. And this turns on a technical legal question of, under the Administrative Procedures Act, whether the Trump administration's termination of DACA was an action that in legalese is, quote, committed to agency discretion by law. So if if the action was committed to DHS discretion by law, then it would not be an action that courts could review. All of the district courts that I mentioned earlier addressed this question and found that it's not an action committed to agency discretion by law, and thus each of the lower courts found that the administration's termination of DACA is subject to court review. If the Supreme Court, however, disagrees and finds that it is not an action that is reviewable by the courts, then the administration could proceed with its decision to end DACA, including what to do with current grants of DACA and pending renewal applications that were pending at the time the court issues its decision. This would be obviously a loss for DACA recipients and their communities, but one upside to this outcome would be that a future administration could potentially then reinstate DACA, possibly with even stronger protections for DACA recipients, and that decision would then likely be protected from challenge in the courts by DACA opponents based on this decision. So that's one possibility. Another possible outcome would be that the court decides it can review the decision to end DACA and also rules that the termination of DACA was unlawful. This would clearly be a win for DACA recipients and their communities. The DACA program could then potentially be resumed to include not only renewals, as have been available under the existing court injunctions, but could also then allow for first-time applications and potentially the resurrection of advanced parole for DACA recipients as well. But a lot of that will depend on how the court's decision is written and the legal bases on which the court rests its opinion. And it's unknown how the Trump administration would respond to such a decision. It is possible that the administration could essentially take another bite at the apple and try to end DACA based on different legal reasoning and a different process, essentially sort of starting the process to terminate DACA over, using a different legal process and on a different legal basis. So there's a lot of unknowns. All of these outcomes that I'm talking about are somewhat speculative because they will, of course, hinge on what the court's not only ultimate determination is, but on their legal reasoning and the legal thinking that supports the decision. Next slide. Finally, the court could find that it can review the decision to end DACA and determine that the Trump administration's termination of the DACA program was lawful. The court's reasoning in that scenario will affect how abruptly the DACA program is then terminated, and the Trump administration would then have to determine, based on the court's reasoning and decision, how to end DACA and how to handle pending renewals and existing grants of DACA. The Supreme Court did not take up the question of whether DACA itself is a lawful exercise of presidential authority, but in its papers to the Supreme Court, the Trump administration has argued that DACA itself was unlawful and an unlawful exercise of presidential authority. We don't see any reason for the Supreme Court to reach this question, and in general, the Supreme Court avoids deciding legal questions that are not necessary to resolve the explicit questions before the court. So our hope would be that the court would not reach this question, but the court could, and if it does reach the question and determines that DACA itself is unlawful, that would most likely put an end to renewals. And then there would be a question based on the court's reasoning of whether existing grants of DACA would remain valid until their expiration date. But again, we don't see a need for the court to reach this question, and it's not a question that the court took up when it granted the government's request to hear the pending cases. So the government has raised the issue of the legality of DACA itself in its papers to the court, but we don't see a need for the court to reach that decision. And just to underscore, the court did not grant or did not raise that question in granting the government's essentially appeal to the Supreme Court.
Great. Thank you, Josh. That was a lot of information, and as you heard, the case outcomes are pretty complicated. So if you do have questions, please type them into the chat box, and we'll ask your questions after all of our presentations. So next, I'll turn it over to Rosa to talk about some of the mobilizations that are coming up.
Hi, everybody. My name is Rosa, and I work for CHIRLA, the Coalition for Humane Immigrant Rights. One of the first things we're going to talk about is what's happening here in the state of California, the mobilization and some of the work that we're doing to amplify the Supreme Court DACA hearing on November 12th. So we're starting off with the statewide relay on November 4th through the 9th, and on the 4th, we're going to start in Sacramento, make our way down to November 5th in San Jose, November 6th. We're going to be in Bakersfield, November 7th. We are going to be in Inland Empire, November 8th in Orange County. And on November 9th, we are going to be in Los Angeles. And throughout this relay, we are hoping to amplify stories of DACA recipients and how DACA has impacted DACA recipients, because we know they're no longer youth. Many of them have families, they have homes, and we're really going to uplift their stories and share where their home is across the state of California. And we know California is the state to the largest number of DACA beneficiaries. And if you want to get involved in any of these different cities, you can go ahead and visit daca.chirla.org. And this is just the build-up action, right? We want to make sure that everybody, not just in California, but across the entire nation knows what's going to happen on November 12th. And on November 12th, we're also gonna really amplify. We're gonna go big, right? So we're gonna start here in the state of California in Los Angeles at 10 a.m. with walkouts. So we have 10 high schools in Los Angeles participating, and these are youth who would have benefit from DACA. So they're really showing what they're doing, how down they are for this program. So at 10 a.m. They're walking out. At 12 p.m. we will hold a rally for DACA, and from 3 to 7 we will have a fest for DACA. And this is all, the fest will take place in MacArthur Park. The rally will take place in front of the federal building on Temple Street. If you're a native to Los Angeles, then the Monocle People is the place to meet at. And for those of you who are wondering, well, I'm not in the state of California, but what can I do? This is just happening here in the West Coast, but in the East Coast, we have a huge rally happening on November 12th outside of the Supreme Court. So if you're in the East Coast in the area, please join us on November 12th. And this is also a really big event on November 12th, because if y'all have been following us on social media, you know that there are about 30 folks who are walking from New York to Washington, D.C., all amplifying what's going to happen on November 12th. So folks are walking 230 miles from New York to Washington, D.C., and are going to arrive in D.C. November 12th. And if you want to join the folks who are walking these 230 miles for 18 days, just to give you some dates to remember, on November 1st, they're going to make a stop in Philadelphia, in City Hall. On November 8th, they'll be in Baltimore. And you can find all of this information on the website that we provided. So if you want to see the marchers who are marching 230 miles, those are some of the cities. But if you're down to meet with us on November 12th, meet us at the Supreme Court, because we're all going to be outside waiting to hear back some of the arguments and some of the feedback that we get back from the judges.
Great. Thank you, Rosa. So I'm going to turn it over to Alisa now to talk about DACA renewals and what people should keep in mind who currently have DACA and want to renew it.
Okay, my name is Alisa Daubenspeck. I'm a managing attorney at CARECEN, and I manage the DACA program. So we do thousands of DACA renewals every year, so I'm going to talk about that a little bit. So right now, because of the pending litigation, DACA renewals are being accepted, no new applications, and no advanced parole at this point. We're seeing processing times vary from, I'm actually going to say 5 weeks, so they can go really fast sometimes, or to a year or more, and it depends often on the complexity of the case and when someone's DACA status is set to expire. So I think everybody knows there's a 150-day window in which you're supposed to renew your DACA, and it's 150 days before your DACA expires. However, CIS usually processes cases that are submitted before that 150-day window. At CARECEN, we've probably done hundreds of, if not thousands of renewals for people who are outside the 150-day window, who want to renew before anything happens to the DACA program. And we've only seen 2 denials of cases that were outside the window. So at this point, we're recommending that people renew because the risk of getting one of those few denials is lower than the risk of DACA not existing at the point that someone is within the 150-day deadline, if that's going to be some point in 2020. So we're just recommending that our clients renew at this point. And I'll talk a little bit more about complexity of cases in just a second. But, it's basically, it's like a balancing of the risks. But at this point, I think, the risks point in favor of renewing. So I'm going to head to the next slide. So people often ask, what makes a DACA renewal complex? And the most common thing that makes a renewal complex would be criminal arrests or convictions, most often since the last renewal period. And then it's especially for crimes that might make someone ineligible for DACA. So that would be any felony, 3 or more misdemeanors, or a misdemeanor that is relating to domestic violence, sexual abuse, firearms, drug sales, burglary, or DUI. And important to note, there's a difference between arrests and convictions. You might be arrested for something and then convicted of a lesser crime. So the fact that you've been arrested for one of these serious misdemeanors doesn't necessarily mean that you wouldn't qualify for DACA, but DACA is discretionary. So they can deny DACA based on anything. So, I'm going to say it later, but if you've been arrested for a serious misdemeanor, it's definitely something you want to talk to an attorney about before you file. Another thing that makes DACA renewals complex is if you have let your DACA expire for more than a year, because at that point you have to go back and you have to show continuous presence since you received, or since DACA, the continuous presence period for DACA, which is June 15th, 2007. So that makes the case more complex in terms of preparation and then also in terms of time that it takes USCIS to process the petition. So definitely, if you're in either of those situations, consult with a good immigration attorney or a reputable nonprofit before filing. And, we see, we'll do occasionally at CARECEN, we'll do renewals for someone who's maybe been arrested for a DUI, but then, convicted of reckless or some lesser crime. And we're seeing success in those cases. So, there's ways that, you can go about applying and potentially being successful. And we haven't seen at this point, referrals to immigration court for removal proceedings. So despite, the Trump administration rhetoric, we really haven't seen much of a difference in the processing of DACA cases. So that's not to say, apply, 100% of the time, but, it's worth consulting with an attorney about. And moving on to the next slide. So in order to renew a DACA, you basically just need your work permit, 2 passport-style photos. If you have a copy of your previous application, it's always very helpful because then we can make sure that we're putting information that's congruent with what you put in previous applications. The money orders for $495 is what is the cost of the DACA renewal. A passport, if you have one, even if it's expired. And then if you've changed your name, you want to bring evidence of your name change. So if you got married, you got divorced, you have a legal name change, USCIS isn't going to just change your name on the forms without evidence that you changed it legally. And then a final court disposition if you have any kind of criminal history. So next slide. So, because we do thousands of DACA renewals at CARECEN, we see a lot of common problems. So I'm going to just go over the top 4. By far, the most common thing that we see is people not attending the biometrics appointment. And unfortunately, you have to attend that appointment in order for them to process a DACA renewal. Even if you did it before, you would think they would be able to keep your prints on file, and I'm sure they do somewhere, but they make you come back and do that every time. So that's something that slows down a lot of applications. But the good news is that if you miss your appointment, you should really just go into the application support center immediately with your biometrics appointment notice, even if it's expired or if the appointment is passed. And usually they'll just see you again. So you don't even have to wait for them to send you another appointment. They will give you another chance, and they'll send you another appointment, but you don't need to wait for that. You can just use the old one and go into the same application support center, and they'll help you. Another huge problem that we see is when work permits don't get delivered. And oftentimes what will happen is someone, they share an address with lots of other people, and maybe someone else picks up the work permit. And so it shows up as approved, they get their approval notice, but they never get their work permit. And it's a huge problem because if USCIS, sees that through their tracking, they ship via USPS, the Postal Service. If they see that it has been received and it has not been returned to them, they're not going to give you another one, which means that you have to pay the $495 again and wait another, several months for the application to be processed. So it's like you never applied at all. It's a big pain in the butt. So my suggestion is to make sure you have a safe mailing address where you can receive the work permit when it arrives, so that you can avoid that nightmare of having to reapply and pay the filing fees twice. Another thing we see is like an arrest that's not revealed on the renewal application. And because they do your fingerprints every single time, there's no point in assuming that if your fingerprints have been taken by law enforcement that CIS isn't going to know about it. They're going to know about it. And so it's better to go forward with all of the information from the beginning so that your attorney or your legal representative can assess your case and let you know if you're in any danger of, submitting the renewal. And then the other thing that we see a lot when people, do their forms on their own is that the forms aren't filled out properly. So a signature box is missed, or the incorrect filing fees were submitted, or a check bounced, or there wasn't money in a debit card payment, account. So it's definitely important to review your forms, make sure that every signature box is signed, make sure all of the information requested by CIS is filled out, and then make sure that, there's money in the account if you're going to pay with a debit card or with a personal check. So if you're trying to renew DACA, I've got, on the next slide, I have a website you can go to at IMMI.org, find legal help, and it will give you a list of nonprofits in every area that can assist with DACA renewals. And then some cities and states, and actually some colleges, have funding assistance. So it's worth checking in, depending on where you live, with your city, state, or potentially your school, to see if they might have any help available for you. And it looks like California's state legislature is set to approve funding for free legal services and filing fee assistance after November 6, 2019. So hopefully, knock on wood, we'll be able to be providing free legal services and filing fees for DACA renewals in California after that point. And that's it for me.
Thank you. So we have a lot of questions coming in about DACA renewals. So I'll give folks a few more minutes to type in their questions. And in the meantime, we've shared out some of these resources already in the chat box. So you can go take a look at our website for our latest documents related to DACA, including a document on where we are now with the Supreme Court case and the timeline around the DACA litigation, and also some tips, the top 5 things that you should know about DACA renewals now that the DACA cases are before the Supreme Court. And we have a lot of other documents too on the NILC.org website that you can take a look at. So for Alisa, there were 2 questions that came in that asked about the 2 cases that got denied at CARECEN. Were they denied because they were filed too early, or was there some other reason?
Yeah, they were outside the 150-day mark. And one of them was like, you know, it was filed maybe a year early, or it was really early. And the other one was filed like, I don't know, maybe 20 days outside the 150-day mark. So it didn't seem like there was any rhyme or reason with like how far outside. It was just the pure fact of being outside the 150-day mark. And unfortunately, because DACA is so discretionary, once a case is denied, there's very little that we can do except for reapply. So those folks had to reapply.
And in those cases of denials, did the fee get returned back?
Sadly, no. Once they process a case, they take the fees.
All right, thank you. And then there was a couple more questions too. I think you answered some of these already, Alisa, but in case people joined a little bit late, there's still some questions about how far in advance should people file their renewal application, and should they file it before next year when we expect the decision to come out?
Yeah, so, you know, at this point, because we don't know how, you know, if the Supreme Court rules against DACA, we don't know how it's going to terminate. So I think at this point, you know, and previously when they terminated it, they, you know, continued to process the cases that were already submitted. They just didn't accept new ones. And so, you know, we don't know how it's going to happen and whether it's going to be better to have your case actually approved before, or if it's okay for it to be pending. So that, you know, there's just a lot of, you know, risks to weigh, I suppose. And if I could read the future, I feel like I could give good legal advice, but I can't do that. So at this point, I think, you know, the balancing of risks is in favor of just applying. I guess the only thing that I can think of is if you're going to reach the 150-day window within maybe a month, maybe you want to wait for that, but maybe you don't, because maybe you want to try to get your case approved before there's a decision on DACA. So, you know, I feel like my guess is as good as anybody else's. I think it depends, like, what makes you feel safe. But at the end of the day, it's like we've only seen 2 denials, and we've done hundreds of these, you know, of cases of renewals where someone was outside the 150-day window. So it's a risk, but it's a small risk.
All right, and there's a question for Josh around scenarios. So is there a scenario where the Supreme Court decides that the termination of DACA was reviewable by the courts, that the termination was unlawful, and also tries to curtail any future attempts by the administration to end DACA?
I mean, I think that's theoretically possible. As I said, the Supreme Court did not, you know, when it takes a case and it identifies the legal questions that it wants the parties to present to the court. And so when it took up these 3 sets of DACA cases in June of this year to be heard in November, it did not take up the question of whether DACA itself was a lawful exercise of presidential authority. So traditionally, the court tries to avoid reaching questions that it doesn't have to resolve the explicit questions before it. So I don't think it's very likely. I don't think there's a need for the court to, nor do I think it's likely that it's going to reach the question of whether DACA itself is lawful, although it's the Supreme Court and it could. Even in this scenario, if it determined that the rescission of DACA was reviewable by the courts, that the Trump administration's process for ending DACA was unlawful, and then in what in legalese is called dicta, or in language that's not necessary for the decision, it noted that DACA was lawful. Even in that instance, it wouldn't tie the government's hands in terms of potentially trying to rescind the DACA program using a different process on a different legal basis, because what's being challenged here in these 3 sets of cases before the U.S. Supreme Court was essentially the process by which DHS rescinded DACA. And the arguments that we're making is that the process by which DHS rescinded DACA was in violation of a federal law called the Administrative Procedures Act, and that prohibits federal agencies like DHS from engaging in decisions that are arbitrary, capricious, or an abuse of discretion. And so we're saying the way that the Trump administration rescinded the DACA program violated the APA, the Administrative Procedures Act, because it was arbitrary and capricious and an abuse of discretion. But that doesn't mean that DHS doesn't have the power to rescind DACA, which is a discretionary program. We're saying but if the government's going to do so, it has to meet the requirements of the Administrative Procedures Act and engage in reasoned decision-making under the Administrative Procedures Act. And particularly in doing so, it would have to explain the policy change and acknowledge the government's prior stance on DACA's legality, and it would have to consider the costs of its decision and the interests that are affected, which mean the interests of DACA recipients who have relied on the DACA policy since 2012, and which the government did not acknowledge or consider in its rescission of DACA back in September of 2017. So even if the court were to say we can review this, the Trump administration's process was unlawful, and by the way, we think DACA is a lawful exercise of presidential authority, that doesn't mean that DHS or the Trump administration couldn't exercise its discretion to rescind the DACA program. It would just have to do so in a lawful way that comports with the Administrative Procedures Act.
All right. And so, Rosa, I know you shared some of the activities that are leading up to November 12th. Are there particular websites people should go to or hashtags people should follow for more information?
Yes, so if you're interested in knowing what's going around your area, right, if you're not from California or DC, you can visit the website homeishere.us, and you'll be able to put in your zip code where you could find what event is happening near you, and also you can follow the hashtags #HomeIsHere in the hashtag Rise for DACA, Rise for DACA is for the state of California.
And then Alisa, a couple of questions about people whose DACA expired more than a year ago. So have you had any issues with people trying to renew their DACA in that scenario? And would you still recommend that they move forward?
Absolutely, yeah. So I would definitely not. Yeah, I would do it with an attorney or a legitimate nonprofit organization. But basically, you just have to show that you have been present since June 15th, 2007, and then other than that, it's a regular DACA renewal. But yeah, so again, it's only available for people who have already had DACA. But if you have let it expire for more than a year, you can renew.
Okay, and in that situation, do you need to show any kind of continuous presence?
Yes, June 15th, 2007. And I've actually seen that sometimes they might only require it since your first application, because you did technically provide all of that evidence from when you applied in 2012 or whenever your first application was. But I would be safe and just provide the continuous presence, evidence since June 15th, 2007.
All right. And this, I think it could be either for Josh or Alisa. It's related to workplace issues. So a person's DACA is expiring next month, and they already sent in the renewal application. Can their employer fire them if they don't receive a receipt in the mail saying the case has been accepted? Is there any other kind of proof that they can show their employer besides that receipt?
Unfortunately, if the worker's application for their renewal of DACA is still pending, and thus their renewal for their work permit is still pending on the date that their existing work permit expires, the employer is lawfully entitled to terminate or suspend that worker's employment, because technically, even though they have a renewal pending, their work authorization will lapse as their DACA will lapse while that renewal application is being decided upon. We have worked with individual DACA recipients who've been able to negotiate with their employers to, for example, suspend their employment until their renewal was approved and their work authorization was thus renewed, and then rehire or reemploy them at that time, but the employer is not required to do that. So it is really important that people apply for renewal well in advance of their current expiration date, so they don't find themselves in this scenario where their grant of DACA and their work authorization lapses, putting them at risk for termination of employment. It's one of the reasons that we and Alisa encourage people to apply 150 days out, if not further out than that, to ensure that they don't face that kind of a lapse in DACA and work authorization.
Yeah, the only thing I would add to that is that, I've had some clients who've brought in their, evidence of renewal, their receipt notice, and their employers have accepted that. So I think it's always worth a try, but it's ultimately up to the employer as to what they're going to do.
And then we have another question about what could possibly happen, which is if the Supreme Court decides that the rescission of DACA was lawful, could they then negate the DACA, or I guess the work permits of the people who've renewed since the original rescission?
It's possible. It will really depend on the court's reasoning. I mean, I think as folks will probably remember, even the Trump administration, when it announced the termination of the DACA program back in September of 2017, was not attempting to claw back or take back existing grants of DACA, but rather were going to allow those existing grants to expire of their own accord. So I think if the court finds that the Trump administration's termination of DACA was lawful, most likely, unless the court actually finds that DACA itself is an unlawful exercise of presidential authority, most likely it would then go back to the Trump administration to determine how to end DACA and how to handle pending renewal applications, and how to handle existing grants of DACA. But again, even back in September of 2017, the Trump administration wasn't trying to take back existing grants of DACA. And so I would be a little bit surprised if we saw that as the administration's response to the Supreme Court decision, if it does find that the process by which the Trump administration ended DACA was a lawful one.
All right. And there's a couple of questions about the financial assistance available. So I don't know, Rosa, if you want to talk about anything that CHIRLA can provide, or Alisa, if you want to elaborate on how much we expect the state of California to be funding and whether that's enough to cover all the DACAmented people in California.
Yes. So I'm actually not sure when we'll start, but in a couple of weeks we'll be able to provide assistance to the $495 for the DACA application. And folks can follow the CHIRLA Facebook, Instagram to find out more information of when we'll be able to provide those resources.
Yeah, the funding is set to be, reviewed on November 6th. And so assuming it gets approved, then it would be, any case filed after November 6th. And then we can, bill those cases to the state and request the filing fees from the state after that point. So unfortunately, it doesn't help anyone who's already submitted their renewal, but it should be available in California after November 6th. and both DACA and CHIRLA will be doing, renewals and filing assistance free of charge.
Great. And for both CHIRLA and the state funding, is there going to be any kind of income threshold that people need to show?
It's 250% of the federal poverty line. So I have to Google that every single time. I just Googled 2019 federal poverty line, and then look for. There's a lot of different charts. Look for 250%. It's dependent on your household size, and so you can just calculate your household size, your income, and see if you're under that threshold. If you're over, then you don't qualify for the funding assistance.
Yeah, and we usually do an intake form right before we assist you. So we provide legal services Tuesdays, Thursdays, and Saturdays. And when we're putting your application together, then we'll go through the income to see if you qualify.
And for people outside of California, hopefully this is giving you ideas of what you can ask your state legislature or your city council to do, because they could authorize temporary or emergency funding to cover either legal assistance or some of the DACA renewal fees. So if you're not as fortunate as us to live in California, this is still something you could try to pressure your elected officials to do. And I wanted to ask both Rosa and Josh, there seems like there's a lot of support for DACA. There's been different what are called amicus briefs or friend of the court briefs that have been filed showing that people are supportive of the program. There's been actions by educators and by students. Can you just share some of the ways in which people have shown their support for DACA?
Yep. So you said it right now. Folks have submitted amicus brief, but I think one of the biggest ways that folks can really show their support is by showing up to the different events that we're having, not only here in California, but across the entire state. If you're a DACA recipient, please visit homeishere.us. You can submit your story, right? Because we really want to show the public and everybody across America of who the DACA recipients are and the impact that you've had in this country. And a lot of the folks, through CHIRLA, we meet a lot of members. There's a DACA beneficiary who she has her own salon and employs 6 other women. We want to hear stories like that. We just met a DACA recipient who she's teaching us sign language, and we just shared her story, and we just want to amplify your story. So please share your story with us with the hashtag #HomeIsHere, Rise for DACA. Submit your story through HomeIsHere. And for all of those allies, the best way that you can help us is by resharing these stories, coming out to the events, and really really standing next to us and standing up with us, because it is a moment, scary times, and we need all the support that we can get. And like I said, the best way you can do that is by going to an event, by sharing our stories, and really showing who we are, because the media likes to portray us as all these different words that I won't mention, but the truth is that we're really fighting for our humanity here. And as a DACA recipient, is all I ask is for you to have compassion, and show us that you're with us by going to an event, because the more people we are, the more united we are.
And then just to speak to the amicus briefs, so an amicus brief, as Shuming mentioned, is also known as a friend of the court brief, and they're briefs that can be filed with the court that bring information or data that's relevant to the court's determination, that the parties themselves may not have space in their briefing to the court to provide. And so in this instance, there was a very wide and diverse effort to generate a large range of amicus briefs from a number of different stakeholders. And I think ultimately, I don't have the exact number in front of me, but ultimately I think over 30 amicus briefs were filed in support of the DACA program from a range of stakeholder categories. So education, higher ed institutions, as well as like K through 12 institutions and other educational institutions. There was a brief on behalf of businesses, on behalf of faith-based organizations, on behalf of medical providers, labor unions, local law enforcement and former senior immigration officials, as well as legal academics, and then a number of legal services and civil rights organizations. So there really was a very wide range of diverse amicus briefs that were submitted to the Supreme Court in support of the DACA program.
Great. And then there's a couple of questions tied to potential consequences. So one is whether the prohibition on USCIS sharing information with ICE is still in place. And then there's another question about if DACA is terminated, does that mean current DACA recipients would be deported?
I mean, when you sign the DACA renewal, I can't remember if it's the DACA renewal or the work permit renewal, but it says that you're authorizing the release of your information to other agencies for the purpose of law enforcement. So, they don't have a practice of referring denied DACA renewals to ICE, but that doesn't mean that it can't happen. We just don't see it very frequently. And it wasn't, they published a memo specifying the types of cases that they're now regularly going to put in proceedings when the person's application for relief is denied. And DACA is not on that list of cases. So it's not, like I'm saying, it's not a common practice, although we can't pretend that risk doesn't exist either. And I think that where that's more likely to happen is where someone applies for renewal and they have a pretty significant criminal history. I think that would be where they would be at most at risk of being referred for immigration proceedings.
And then on the flip side of that, if the Supreme Court decides that the termination of DACA was unlawful, does that mean new DACA applications for people who've never had DACA before? So the initial applications would be accepted and processed?
I mean, I think it will depend on the particular reasoning and language that the court uses, but I think very likely if they find that the Trump administration's process for terminating DACA was unlawful, then there, again, depending on the language of the court and the legal bases on which that decision rests, I think it is very possible then we would see the resumption of first-time applications in that situation.
Okay. And Josh, there's some questions about the issuing of the decision. One person asked if there's any chance it would be issued this year, and somebody else asked if you had a more narrow window than between January and June of 2020. That would be nice.
Unfortunately not. The Supreme Court, the U.S. Supreme Court pretty much has very broad discretion in terms of how it conducts itself. I think it's pretty unlikely that we would see a decision as fast, given that the oral argument is not until November 12th, that we would see a decision within 6 weeks, i.e. by the end of the calendar year. I mean, theoretically, it's possible the Supreme Court could turn around and issue a decision very quickly, but that seems very unlikely and is not generally the speed at which the Supreme Court issues decisions. The current Supreme Court term runs through the end of June of 2020, which is why we anticipate a decision will come between November 12th and the end of June. Often with decisions like this that are high profile, with a lot of public scrutiny, that have a lot of political kind of implications, the court will often take longer to issue those decisions, sometimes till the very end of June. And so, we're really just we don't have any sense of how fast or how likely it is that the Supreme Court will issue a decision before the end of June. And theoretically, they could even hold it beyond the end of their current term, although that's also extremely unlikely. So we feel it's pretty likely to come sometime in 2020 between January and the end of June, but unfortunately can't really guess any further than that.
So I think we have time for 2 more questions. So one for Alisa is related to people who are asking if they're DACA and work permit expire in October 2020, so a year from now. Should they still apply now, and how does that affect them losing some of the time they would have had originally on the work permit because they're applying early?
Yeah, I mean, when you apply a year early, you do have an overlap in work permits. That's also the situation where they take the longest in renewing. So oftentimes if you apply with a year less, they'll take far more than the 5 weeks that it takes someone who's within the 150-day window period. But at this point, I would say, like, you're not going to get to the 150-day window point during any time that it's safe to wait for the Supreme Court decision. So basically, I think at this point, what you're risking is, $495. What you have to gain is an extra year on your work permit, which, hopefully takes you to, past the election and potentially to a new presidency, knock on wood. So, it's like it potentially keeps you in status, until there can be something more permanent, a more permanent solution for DACA recipients. So, like, I think it's a good idea to do if you can afford the $495 and you're willing to risk it. And because you're not going to be within the 150-day window regardless, I would say you could do it now, you could do it in a month. Because we don't know how DACA would terminate, we don't know what the decision is going to be. It's really hard to predict. So you just kind of have to do what feels right to you, I think, at that point, because nobody can predict the future.
All right, and we'll let Rosa take the last question, which is, are there any ways that specifically young people, such as college students, can get involved to support DACA, even if somebody is not able to travel to a march or support financially?
Yes, so you could volunteer. You could volunteer for any of the events, especially here in California. But I think I mentioned it earlier. One of the best ways that you can do is if you yourself are a DACA recipient, you could share your story with us on the homeishere.us or the daca.chirla.org. Or if you know someone who is a DACA recipient, you could share with them this website. And one of the biggest ways that you can actually help is make sure your college or your university, wherever you attend, is providing resources to undocumented students. So here in the state of California, we're very fortunate to have passed many legislation that are going to help undocumented students continue thriving in college and universities. So make sure you're talking with your college president and asking them for in-state tuition, right? If you're outside of California, you could meet with your president, you could meet with your state legislator and ask for in-state tuition to provide financial resource for undocumented students. You can even ask your school to open a Dream Resource Center, or have a Dream Liaison, a person designated to help undocumented students on your campus. And a Dream Resource Center is a center that is a safe space for undocumented students to ask questions that sometimes are scary to ask in other places.
Great. So with that, we will wrap it up, and we will send all of you a link to the PowerPoint and the recording tomorrow, and they'll also be posted on the NILC website in a few days. So just wanted to thank our panelists for providing such comprehensive information, and thank you all for attending. And please continue to visit NILC's website and follow us on Twitter to get all the breaking news around DACA.